Afternoon, Salt Lake City. Welcome to episode 21 of Talk with Ted, a show about nothing. It's gonna be full of nothing today because I've got Davis County District Attorney Troy Rawlings sitting to my left, and I'm going to ask Troy to be patient a little bit and sit quiet for the first segment while I carry on about I don't know what, probably a little bit of basketball. But then we're going to get into some details about the life of a prosecutor here in Salt Lake City, Utah. And many of you may know the name Troy Rawlings because he was the prosecutor to finish up the case against Mark Shurtleff, our three-time elected former attorney general. Mark served from 2000 to 2012, and then he faced criminal charges in 2014, and ultimately those charges were dismissed on the prosecutor's motion, on Mr. Rawlings' motion, and he's here to discuss some of that today, as well as some other interesting cases that he's been involved in. And he is not unfamiliar with the media and television because Troy's been on lots of programs. He's served as the Davis County District Attorney for a number of years now, and he's going to have a lot of good stuff to share with us. But welcome. It's a little rainy out there today. What is it, April 2nd? So I didn't get any great April Fool's jokes played on me. Well, I had one. I might raise that later because it is Mark Shurtleff played a little joke on me. I'll share that with you in a bit. But my name is Ted McBride. I'm an attorney here in Salt Lake City, transplanted New Yorker, and an aspiring sports radio talk host. That's what I'd really like to be, Troy. So I got to put that pitch out here. A little rainy out today, still a little bit cold, and we've still got a lot of snow in the mountains, and I'm hoping that the weather doesn't get too warm too fast where all that water comes running off too quickly, because there's a pretty good snowpack up there. They're talking about Lake Powell filling back up maybe this year because of the amount of snow that we've had. So it's a very welcome thing, all that moisture. We certainly need it here in the West. And a little rainy and cold, and I got a new set of wheels. I indicated last week that I had a car accident and regrettably and unfortunately destroyed my beautiful Dodge Charger. I'd like to call it my cop car, Troy. But I've replaced that with something newer and better. I got a Dodge Challenger. It's crazy plum is the color, so I got a purple Dodge Challenger. And so if I get any tickets, I don't know if I could coerce Troy Rawlings here to have some influence on the police, but knowing the type of guy that he is, I don't think that that would be a valuable resource to try to get me out of anything. But Troy's an elected official that doesn't take campaign donations, doesn't solicit them, and won't take them. And he's just one of the most credible lawyers and important lawyers that we have here in the state, and he's going to have some great stuff for us. A couple of weeks ago, I did a show about the NBA, and we had the incident here in Utah with the Utah Jazz and Russell Westbrook, and the ugliness that went on there, where a fan got into Russell Westbrook's face and said some rather insulting things, and regrettably, Russell Westbrook had a bit of a visceral reaction. And for those of you that aren't major NBA fans, Russell Westbrook is an NBA All-Star, a phenomenal player. With probably the most passion for the game that anybody that plays the game today. And it was a little bit of a ugly scene, and I had talked about the Utah fan base and the challenges that we have here and how we really need to get it together. Well, last Friday evening, I had the great pleasure of taking my daughter to the Utah Jazz game, and they faced the Washington Wizards, and in a great matchup. The Jazz beat the Wizards. Our local hero, Donovan Mitchell, lit him up for 35 points. That kid is just absolutely unbelievable. We're lucky to have him. They've got a mural of him now downtown at the mall, and hopefully we can do our best to convince Donovan Mitchell to stay here for his entire career. And it was a fantastic game, and I also witnessed some efforts by the Utah Jazz. There are signs posted in the arena and a public service announcement during the halftime break for the fans to behave and maybe monitor themselves a bit. And the game was without incident, and it was nice to see those things implemented because we're so fortunate to have that great Utah Jazz franchise here and the great quality entertainment that the NBA brings. And hopefully the ugly days of the Utah fan base just being a little too aggressive going into that arena. We need to appreciate these athletes that work for us and play for us and entertain us with that great athleticism. And I shared that program with a number of my friends on LinkedIn, and I've got a growing list of friends on LinkedIn, including Josh Hart. And if we've got any NBA, real diehard Utah NBA fans here, Josh Hart played for Villanova a couple of years ago. He was a Big East Player of the Year. He now plays for the Los Angeles Lakers. But he was drafted by the Utah Jazz, number 30th, a couple of years ago. And so, Alan, my list of NBA players is growing on LinkedIn. I've told you before I've got Rick Barry, the legend Rick Barry. And I got friended just the other day by Sam Mitchell from TNT TV. So I'm trying to get the attention of some people at NBA TV because I think that I'll pitch it again. I'd love to host a program where I interviewed visiting NBA players as they come to town and to humanize them a bit and to have our fan base familiar with these great athletes and entertainers that are coming to entertain us. And of course, we need opponents. It'd be no fun if it were just the Jazz versus whoever. So we need these great opponents, and we need to cherish them as well as our own, the likes of Joe Ingles and Derek Favors and Rudy Gobert and Ricky Rubio. We've got a great Jazz team right now. They're an exciting team to follow. It's great to cheer them on, and it's great to see that efforts are being made to just control our fan base a bit so that we don't ruin what a great thing we have here with the Utah Jazz being in Salt Lake City. And of course, they used to be in New Orleans. That's why they're called the Jazz, but I just love the Jazz. And I had the great honor and privilege of meeting 1983 NCAA champion and Utah ambassador and legend Thurl Bailey at halftime and again after the show, and he did an autograph for my daughter on the sign that she had done. And so we just love the Jazz, we love the organization, and we are glad to see that it's things are settling down there, because Utah can't afford another black eye, so to speak, with the fan base and the NBA. Last week I had on my cousin Clay Patrick McBride and Logan Blythe, Chad Blythe, Logan Blythe's father. And Logan was a Boy Scout who'd been approved for his Eagle Scout Award here by the local Parks Commission, and that project was sent overnight to the national chapter in Washington, D.C., and Logan has Down syndrome and was not able to complete all of the requirements as written, and the Boy Scouts kind of harshly ripped away that opportunity from him. So we discussed that last week, and the old shows are available on LinkedIn or Facebook. You can find me on those social media forums, and feel free to reach out and friend me. It's Ted McBride, and those shows are posted there. If you're interested, you can go back and listen. And I've had some really great opportunities to discuss some interesting things, and I think this show about nothing, as I like to call it, is really a law / philosophy / pop culture, and within the pop culture it's mostly basketball, but I've really enjoyed it. And I had some great shows about Alcoholics Anonymous, about housing and sober living homes. I had Professor Amos Giora from the University of Utah on talking about bystander liability and efforts here in Utah to change the law on bystander liability to call 911 where someone witnesses someone in distress. I had a show about mob rule and the lawsuit challenging the modifications to Prop 2, the medical marijuana. I'm drawing a blank, the referendum that was passed back at the election, and the legislature called an emergency session and changed that, and there's a lawsuit challenging that, and I took issue with that lawsuit, indicating that it was a bit of a mob rule mentality. And there's some great shows, some great old shows, and this is number 21, and it's going to be Troy Rawlings versus Mark Shurtleff, maybe is what I could call it, tongue-in-cheek. And again, my name is Ted McBride. I'm a personal injury civil rights lawyer here in Salt Lake City. I've got an office at 405 South Main Street, right on the same block as the Matheson Courthouse. And you can find me at tedmcbridelaw.com. And I'm sharing space. Mark Shurtleff is with me up there, and he and I are doing our best to restore his reputation. And over the last year, I've gotten to know Mark very, very well, and I care deeply about him. He's a wonderful man who suffered a terrible injustice, in my opinion, in having to defend criminal charges that were baseless in our position. That's what we claim in our federal civil rights lawsuit that we have pending in the federal district court here in the state of Utah. And I got to tell a quick story. I was at a wedding in New York City back, 15, 16 years ago now, and a friend of mine married a woman whose father was friends with Joe Pesci, the great actor, and Joe Pesci starred in the movie My Cousin Vinny. And I found myself with my father on the back deck at a fancy restaurant in Central Park, New York, smoking a cigarette with Joe Pesci. And it was a wonderful experience, and Joe was telling us a bunch of stories. And Joe was in the great movie, My Cousin Vinny, and there's a scene in that movie that really resonates with me, and I've told this story a number of times in connection as a lawyer, whether I'm picking a jury or doing an opening statement. But he was defending his nephew, Joe Pesci was, and he was a New York lawyer, a bit of a hack, and he had to travel to the South to defend his nephew in a case that was a murder case. And his nephew had stolen a can of tuna fish. And then he was being interrogated by the police, and there was a bit of confusion in the discussion about what they were talking about. And the kid said, "Yeah, I did it," and he was admitting to stealing the tuna fish. And the interrogator then indicated, no, we're talking about the murder. And he said, I did what? And he said, "You killed so and so." And the kid said, "I killed Joey?" Exclamation point. And when the case came on for trial, that interrogator testified that his response was, "I killed Joey." And he took the exclamation point and changed it to a period. And just changing that little bit of context in that sentence, was the difference between perhaps a lifetime conviction on a quote-unquote admission or with the proper context with an exclamation point. It was an exclamation is exactly what it was. "I killed Joey," instead of "I killed Joey." And that great scene and that little change of context, it's all it was a change in the punctuation, really, affected the entire outcome of that fictitious case. But I see parallels in the Mark Shurtleff case with the My Cousin Vinny, because I go through the charges and the complaint and our civil rights lawsuit, and it just seems like time after time that things were taken out of context and manipulated to make it appear that our great and revered Attorney General was willing to accept improper gifts or have some improper influence over criminal investigations and prosecutions, when in fact that was not the case. And one of the most stark examples that we cite in our lawsuit was a situation where Mark, when he was hospitalized in 2007 or 2008, was approached by someone with a bribe. And Mark notified the FBI, wore a wire, and tried to get this gentleman to repeat the bribe. And then, incredibly, in the search warrant affidavit, that encounter and those conversations weren't fully disclosed, and it made it appear that Mark was willing to entertain such a thing, when in fact he was working with the FBI to try to prove that he was being bribed. And that was just one example of many in his case that we're set on trying to clear the record on. So we've got a commercial. If you didn't understand that, I'll try to clarify it a little bit more, but I'll be right back with Davis County Attorney Troy Rawlings. Welcome back to Talk with Ted, number 21, Troy Rawlings, Davis County District Attorney. How are you, Troy?
I'm doing well today, Ted. Thank you for the
if you could
invitation. And it did my heart good to see your car when I came into the parking lot today. You have the dream car that maybe every middle-aged man wishes that they could acquire.
Middle-aged? I'm 52. I'm only 52, Troy.
I know. I'm 53. I've got you by a year.
It's a nice car, isn't it?
You got the car before I do.
Uh-huh.
It's nice.
It's a beauty. It's an all-wheel drive Challenger. It looks like something from the late 60s. Reminds me of the car we drove around in high school.
It reminds me of Starsky and Hutch.
Little Starsky and Hutch, and it's purple, so it's hard to miss. But there's only two ways to drive that car. You know what they are?
I don't want to know what they are since I don't have one.
They're fast and slow.
There you go.
And so far, I've been driving it slow, but yeah, I'm enjoying it. Introduce yourself for us, if you would.
Yeah, primarily, I guess the most important thing: husband, father. I've been an attorney since 1994. I started out my career as a defense attorney for about 6 years. For reasons that we may or may not get into today, depending upon where you want to take the conversation. In January of 2000, I took a pretty significant pay decrease, a cut to join the Davis County Attorney's Office as a prosecutor. There were some specific reasons why I did that. So I've been prosecuting ever since January of 2000. My primary caseload while I was a deputy before being elected in 2006 and
a little closer to
taking office was primarily prosecuting sex offense cases, child physical and sex abuse. There was a good mix of domestic violence, homicides, drug cases, those sort of things. But my primary assignment was a special victims prosecutor handling the child sex offense cases, which I still do to this day. I handle all of those cases in our office that get assigned to Judge John Morris. We divide things by caseload, so I'm still actively prosecuting my own caseload today. I take my turn screening cases, special prosecutions. I think that the boss in the office should not just lead by policy, but also by example. Should understand what's happening in the courtroom, keep up with the rules of evidence, all those things. So I'm still actively prosecuting to this day. Got elected and took office over what I believe is probably kind of like you talk about NBA. I think I've got an all-star lineup in our office. The prosecutors, the investigators that we have, those that we have been able to recruit and retain. I think the Davis County Attorney's Office is a first-class law firm that happens to specialize in prosecution, but our attorneys are professional, practice at a high level, and kind of my primary policy for them that they seem to follow is don't do stupid stuff. And obviously there's a lot more behind that simple statement, but they kind of like that policy. So that's kind of the little bit of the background into what I do now. My journey to become a prosecutor, if you want to get into that today.
It's easy. I'm not going to have to ask a single question. I'll just let you go.
It's like, it's like my wife says, maybe I don't talk enough at home, but I talk too much in public. So since we're kind of dealing with a public audience here, I can be a wind-up doll toy sometimes, so shut me down when you want.
How many lawyers do you supervise up there? How many do you have in the Davis County Prosecutor's Office?
We have 18. We have 16 prosecutors. That includes myself, so 2 in our civil division. We just hired a 3rd that's just starting. So it's I guess kind of a smaller office as far as the number of attorneys goes. But we have 52 members of the staff. That includes victim advocates, investigators, support staff, legal techs. Rehabilitation services specialists to help people try to get their lives turned around. So the total office size is 52, and of that 52, 19 of them are attorneys, including myself with the new one we just hired.
Now, I'm from New York, and in New York we've got the district attorney does just criminal cases.
Yeah.
And then you have the county attorney that would defend and handle other civil matters. But you do both in your office?
We do both, and quite frankly, Ted, you just raised an interesting issue. I think the better model is the model that you have in New York personally. I don't see that changing in Utah anytime soon, though.
Why do you say that?
I think maybe costs a little bit, and just the way that the system is set up now, you can have it would take a legislative change. You can have a district attorney's office, but it has to be district wide. So it would be Davis. In our district, it would be Davis, Morgan, Weber. You'd have to have all 3 to have a true district attorney's office that only focuses on criminal prosecution. Statutorily, the way it is now, unless you have a district attorney's office, it's a county attorney's office. And what's interesting about that is, just give you an example. Sometimes why we have to conflict things out. So I wear both of those hats. You may have
civil and criminal.
Civil and criminal. You're exactly right. You may have a situation where our 2 civil deputies might be involved in issue, might come to the Human Resources Department. There might be allegations of impropriety, maybe even that is criminal, ultimately that ends up being that way. Yet it's our civil division attorneys who are dealing with it first. They may be involved in policy issues, in discipline issues related to the employee in question. Yet at the same time, then our criminal division may have to get involved in those cases as well. So that the very nature of wearing 2 hats sometimes, and it's not often, but it's regularly enough that I think at some point, I have talked to legislators about it in the past, about possibly going to a model like you had in New York, where we have a true district attorney's office that only focuses on the criminal side, county attorney's office that only focuses on civil issues, rather than the commingling of the 2 that can sometimes happen. So we have one elected wearing both hats.
Yeah, and I could maybe see a situation where there was an employee that's maybe subject to some disciplinary matters by the civil division, which then grow into criminal matters, and then the criminal defense lawyer may say, oh, well, wait, you improperly investigated, or your administrative proceedings were improper. Is that the type of thing where there might be a conflict?
Exactly. Or they may say, if our office were to pursue criminal charges, and we do conflict those out to avoid this very problem, but are we pursuing criminal charges to leverage them in the employee discipline proceeding, to maybe walk away, to not challenge, or vice versa?
Right.
And so, yeah, those, because our civil division does get involved in all of the significant human resource issues in the county. If there's allegations maybe of misuse of resources or monies, oftentimes those go through the civil division first. But also, they're the legal advisors for all the departments in the county under my direction, so they go out and they give training. For example, they'll go out and give training on Government Records and Management Act and the Sunshine Laws. And then if somebody violates that, maybe one of their defenses is going to be, well, I thought I understood the civil division attorneys to say
they're going to
that we
point
could
to the lawyer and say, we got the advice from your office.
Exactly so.
And now you're trying to prosecute us criminally.
That's right. So that's why we don't do it. So what it leads to is conflicting out more scenarios than we arguably would have to. I think more than people know, we conflict things out to Weber County, Salt Lake County, Summit County. We all do it with each other. We kind of cross-share and pollinate so we can avoid these kind of conflicts. But your question's really intuitive, that I think a lot of people don't know and understand. But because of the very nature of the dual responsibilities that we have statutorily as county attorneys, both civil and criminal, it leads to those situations. We had a big one not long ago in our office that came to us that took a lot of time, effort, energy, and resources. Weber County conflicted out to us allegations against former County Commissioner Kerry Gibson, because their civil division had been involved in issues on the civil side related to contracts, water use mitigation, flood channels, the repair, the reconstruction, negotiating the contract with the federal government. So their civil division attorneys actually would have been witnesses in what the allegation was that could have potentially been criminal. So Chris Allred contacts me and says, hey, we can't do this. I say, you're right, so we'll take the time and invest it and put in the effort for them. They do that for us on occasion too. But your question is really a good one. But that's because of that model. Sometimes we do have to conflict cases out to other jurisdictions.
Okay. So let's slow down and let me back you up a little bit.
You got
Troy.
it.
You're a hoop fan, right?
I love hoops. That was my sport as a kid.
Yeah, me too.
Yep.
I just love basketball. Jazz fan?
I am. I am a Jazz fan now, a converted Jazz fan.
Me too.
I grew up a Lakers fan. My dad's first job when he graduated from college at Utah State was in Los Angeles for Price Waterhouse. So I grew up in Los Angeles in the days of Jerry West, Elgin Baylor, Gail Goodrich. My dad used to go to the games, and so I was kind of weaned on the Lakers as a child. It took me a while to break away from that and become a Jazz fan after moving to Utah when I was in high school. But yeah, I got converted, so I'm a Jazz fan.
Is the family originally from Utah?
Idaho. My parents are from the Idaho area.
Okay. And then you grew up in California, moved to Utah when in high school?
Close. Moved to Wichita, Kansas first, the Wichita, Kansas area, and then to Utah when I was 16.
Okay. Where'd you go to college?
Went to University of Utah for my undergrad, and then went down southeast for law school to Alabama. Yeah. Roll Tide.
Charles Barkley territory.
Yeah,
right?
Well, Charles Barkley's Auburn, but it's so I would say it's Charles is a usurper, but his team happens to be playing really well right now. But it's actually Alabama Crimson Tide territory.
Okay.
So Auburn, when you grow up in when you live in the South like I did, it's intense. And I was a football fan. My first year in law school, Alabama won the national championship under Gene Stallings down in Miami in an incredible game. So I kind of got converted to that whole atmosphere, the environment, the love, the passion that exists down there. But that Alabama-Auburn rivalry, it's intense. People know the Utah-BYU rivalry here. That's just as intense down there.
Is it nasty down there between them, between the fan base?
It can be. Not always. The majority of people are civil, but they do take it seriously, and it hurts. It hurts for 364 days until the next year if you win. So fortunately for the Crimson Tide fans, we've been handling Auburn for the most part the last few years.
Well, I got to tell you, I used to be passionate about basketball in the NBA, and my favorite player of all time is Patrick Ewing.
Okay.
Warrior. And
Yep.
when I was in law school, I used to tune into the AM radio and listen to the games up in Vermont, and I'll never forgive the Knicks for letting Patrick Ewing go in 2001 in the way they did, and I think that's why they've been terrible since. But I used to vacation here in Utah in the 90s, and I'd heckle Karl Malone and the Utah fans. I called him the paper boy. They called him the mailman. I called him the paper boy. But Karl Malone was a great player. Of course, he's from the South, a LSU grad, right?
That's right.
And John Stockton in that great era. And now we've got it blossoming again because this Utah Jazz team is really exciting.
They are. They play hard. They, for the most part, want to win. Kind of like they seem to get better as the season progresses.
That's true.
The last couple of years, and so I think that's also a credit to the coaching staff as well as that you got players that are willing to work hard and improve and do what they need to do. So yeah, I'm impressed with the organization and the coaching staff as well as how the players respond and how the effort they put out there on the floor.
Yeah, and even the organization's response to the ugly incident with Russell Westbrook, they did a beautiful job in handling that. Gail Miller came out on the next game and spoke to the crowd, and there were T-shirts distributed between the two teams and some show of solidarity. And hopefully that people will better appreciate that these NBA guys don't have it easy. It's a hard job.
No question, and the Jazz are a class act, as you suggest. So I share your passion for the love of the game, even for Patrick Ewing. For what it's worth, Georgetown
Ewing
University,
fan. I like even
John
more.
Thompson. Back in the day, I was a Sleepy. Going back to the days of Sleepy Floyd, Eric Sleepy Floyd.
Sure.
I was a Georgetown fan too, as far as the hoops and stuff. So
Yeah.
Patrick Ewing was one of the players I admired back in that day as well.
And Patrick Ewing was a real subject to a lot of racism himself. He came from Jamaica and moved to Boston, and when he was deciding where to go to college, he was just ripped mercilessly, and had considered going to North Carolina to play alongside with James Worthy and Michael Jordan, and ended up at Georgetown, I think, because he was comforted by the great John Thompson. And, of course, the rest is history, and now he's the head coach there.
Agreed. It's kind of an interesting story, but I think you're exactly right. John Thompson seemed to be to me more than just a coach, but a father figure. Yep. Somebody who truly cared about the player's success in life as well as on the court.
And, almost all of his players graduated from Georgetown.
Indeed.
I think Allen Iverson played at Georgetown, right?
Yes.
And left, I think, after his sophomore year.
His sophomore year.
But John Thompson was a great man, great coach, great mentor, and I'm sure that Patrick Ewing's doing the same for the kids that he's in charge of now.
Yeah, you're right. I didn't know you're inviting me to a trip down nostalgia lane today, but I'm kind of enjoying it.
It's not going to be all about Mark Shurtleff or Harry Reid. And we're probably coming up on another commercial in a minute or two. But, Troy, I'm looking at a couple of things off of your website, and you take tremendous responsibility and accountability for being a criminal prosecutor, don't you?
I do. The decisions that prosecutors make impact people's lives, and that's kind of one of the other, I guess, if there's a gospel of our office besides using good judgment, don't do stupid stuff. And that drives because we realize every day when we come to the office that what you do is going to matter. It's going to matter to the lives of all the individuals concerned. It's going to matter to the lives of victims if you file or don't file, or what you do to the lives of defendants, their careers, their families, the community, the constitutional issues involved. So every day in America, I think prosecutors are far more, and I don't like to necessarily use the word powerful, but to a degree, it kind of applies.
You're powerful.
Yeah, the power that prosecutors have over the daily lives of humanity is kind of intense, and I think it's been interesting to me to watch the last couple of years where people are kind of seeing how that plays out a little bit through what happens, with the Department of Justice and how somebody like at some point in time, somebody like Robert Mueller becomes such a central, powerful figure where basically the political and legal world are stopped revolving around what Robert Mueller's going to do. It kind of
And
highlights
then
a
who
little
oversees
bit.
him?
Yeah, exactly. On a big grand scale, the power that prosecutors have, and so I kind of continually remind our folks about that in their staff meetings and their decisions, that what you do matters, and so do it with as much information as you can, as much evidence as you can. If you need to do follow-up and send it back to the police and the case isn't ready, do what you need to do, because you got to be mindful as a prosecutor that what you do matters, because you're impacting humanity.
Now, I've been a civil prosecutor my whole life. I prosecute personal injury, civil rights cases, discrimination cases. I don't have the same considerations for my defendants as you do.
Yeah, that's correct. One of the main responsibilities, in my view, of prosecutors is to be a check and balance on the potential abuse of government power. Believe it or not, as powerful as prosecutors are, it gets to the issue of why I became a prosecutor when I was a defense attorney for 6 years, which I wanted to do. Coming out of law school, I went to law school to become a defense attorney. Watching the old black and white Perry Masons growing up with my parents, I knew from a little kid that that's what I wanted to do. After about 6 years of it, I realized, you know what, as a defense attorney, the only power I have is the power of persuasion. If I believe that my client's being wrongfully investigated, charged, that there's constitutional violations, I could try to persuade somebody, a prosecutor, a judge, a jury, but at the end of the day, it was the prosecutors who basically held the keys to the criminal justice system, the keys to that car to move it forward or shut it down.
And to prove that you're not making this up on this segment here, I've got from your website, you've got prosecutors are the first line of defense, or a check and balance on potential police abuse of governmental power.
That is a correct statement, and that's it may surprise people to know we decline to prosecute about 1/3 of the cases that come into our office every year.
We've got a commercial coming on, and when
Okay.
we come back, we're going to pick up right there. I'll be right back. Talk with Ted, Davis County Attorney Troy Rawlings. Welcome back to Talk with Ted, a show about nothing, number 21. It's April 2nd, 2019, on a little bit of a rainy and somewhat cold afternoon here in beautiful Salt Lake City, Utah. And I've got with me a wonderful guest, a man of integrity, if you can say such a thing about a lawyer. I got him chuckling. Troy Rawlings, our Davis County prosecutor. And we're just discussing, getting a little bit ahead of ourselves. We'll try to slow it down, back up a little bit, but the special role of a prosecutor. And Troy, before I get back to you, I want to point out to our listeners that there are special ethical rules that apply just to prosecutors, to criminal prosecutors. And I don't have to worry about these rules because I'm not a criminal prosecutor. But I'm going to read 3.8, Rule 3.8, Special Responsibilities of a Prosecutor. The prosecutor in a criminal case shall, A, refrain from prosecuting a charge that the prosecutor knows is not supported by probable cause. B, make reasonable efforts to assure that the accused has been advised of the right to and the procedure for obtaining counsel and has been given a reasonable opportunity to obtain counsel. C, not seek to obtain from an unrepresented accused a waiver of important pretrial rights, such as the right to a preliminary hearing. D, make timely disclosure to the defense of all evidence of information known to the prosecutor that tends to negate the guilt of the accused or mitigates the offense, and in connection with sentencing, disclose to the defense and to the tribunal all unprivileged mitigating information known to the prosecutor except when the prosecutor is relieved of this responsibility by a protective order, etc. So really kind of a higher standard of ethical rules apply to a prosecutor. Would you agree?
Absolutely, and it should.
You've got to really kind of play both sides, where I only have to play one side.
Yeah, correct. Prosecutors should play fair. That is the gold standard, and it's the way it should be. One of the issues we may get into a little bit today is what happens when they don't. But across the country, there is some interesting issues related to prosecutorial misconduct. If people want to do any research in that, I'm so concerned about prosecutors. But basically, to sum up everything you just said, our constitutional principles of equal protection and fundamental fairness, due process. That's the job of a prosecutor in making sure you're protecting public safety At the same time, you have to protect people's constitutional rights. And playing fair is part of the way to do that. And those principles you had just outlined all feed into that basic notion as to how a prosecutor is supposed to operate when they're trying to deprive somebody of life, liberty, or property.
Did these ethical rules come into play in the Mark Shurtleff case and your decision to make a motion to dismiss that case?
Unquestionably, yes.
And can you elaborate that a little bit?
I can a little bit, and that would probably take us the whole show if we were to get into everything. I will highlight a few things for you, though, Ted, and for your audience that absolutely played into that. A couple things.
First, can I just set this up? This isn't the first time that you and I have met, correct?
Correct.
In fact, you know that I represent Mark in the civil rights case against the FBI and others.
I do.
And the case against Mark Shurtleff, that was investigated by the Federal Bureau of Investigation, and then the Department of Justice refused to prosecute that case. Is that right?
That's correct.
And then that case, the FBI originally went to the Salt Lake County District Attorney, and those charges were filed.
Correct.
And then you were subsequently appointed.
Yes, Sim Gill and I was asked to get involved in the case earlier than that. After the cases were filed and they were split, I was assigned to the Mark Shurtleff case.
And you say the cases, that's the John Swallow case?
Correct.
And John Swallow was the acting attorney general. He was the incumbent, if you will, after Mark Shurtleff.
You got it.
And there were the two separate cases, and then you took over Mark's case.
Correct.
Okay. Ultimately, it was dismissed.
It was.
First, was it unusual that you were prosecuting a case where the FBI was the investigative it wasn't a local police, it was the feds, then you were working with the FBI on a state case?
So unusual. I had never done it before, and it was a big enough deal that James Comey himself, who was the director of the FBI back in 2014, came out to Salt Lake. He also had conversations with the special agent in charge here in Salt Lake while he was back east in D.C. too about this case. But James Comey actually came out personally in late August of 2014 to kind of take the temperature, encourage, rah, this is an important case. You guys, have to see this through. You have to pull this off, because what Comey wanted, what the FBI was hoping at the time, is that this case, if we could successfully prosecute two former attorney generals, could become a model for prosecution around the country to a degree. It's not unprecedented. It's not unheard of. It's happened at various points in other jurisdictions, but it's kind of rare. It's not the norm. Most of the time, the FBI cases go to the United States Attorney's Office through the DOJ. Like most times here in Utah, it would have gone through the United States Attorney's Office here in the District of Utah, but there was some conflict situations that prevented that from occurring, and the DOJ, PIN, Public Integrity in D.C. had already walked away. But it was so unusual that Comey came personally, and Sim Gill and I were invited to the FBI building in August of 2014 to meet Comey. He had a closed-door meeting with the FBI agents and the special agent in charge that we weren't privy to, but we were privy to what they told us happened in that meeting with Comey. And then James Comey did briefly meet Sim Gill and myself, expressed encouragement and that this was a great thing that was happening again, because they wanted to do it more. So they wanted to use this case almost as kind of a test pilot for how the FBI can work with local prosecutors on particularly public corruption cases.
But what was the nature of the conflict or the issue that led the Department of Justice to have a problem or to not prosecute the case?
There were multiple things. One of the issues related to Jeremy Johnson, there was conflicts related to Jeremy Johnson.
And that's a witness in the case?
Yeah, Jeremy Johnson was a key significant witness in the case. There was prosecutions by the United States Attorney's Office, investigations into Jeremy Johnson.
Now, as the defense lawyer, I want to know all that information.
Yeah, everything. And you're entitled to know it all. If things that would be material to your defense under Brady Giglio, you're exactly right. You're entitled to know all that information. But there were some other levels or layers of conflict, too, that I don't want to get into and articulate here today. It wouldn't. I need to be somewhat restrained in what I do talk about and what I don't.
You tell me. I can't answer that one if I ask anything.
Yeah.
That's
the issues related to the Utah United States Attorney's Office, District of Utah. I'll stay away from talking about today.
Okay. There did come a time, though, where you asked them to take the case back over in June of 2015. I've got an article here from the Deseret News, so it was an ongoing issue?
Yeah. I asked them to take the case back over because I was, quite frankly, frustrated and annoyed with some of the things that had happened. One thing that is hard to articulate clearly and concisely in this format because of the compacted length of time we have was the significant federal oversight and interference with this case. Because, as I told you, this was important even to James Comey. That was the level that this case was being...
Right to the top.
Absolutely.
James Comey, we all know him from the Hillary Clinton email server investigation.
You got it. This case was a big deal to the FBI and to the Department of Justice to see it go forward in Utah. But the feds had put a lot of restrictions on what we could and couldn't do with the case. For example, who we could and couldn't interview, search warrants that we could and couldn't execute. We had, and the agents themselves, I guess I can't speak for them, but this case was headed in a particular direction until James Comey said it wasn't. And so I was extremely frustrated. So at one point in time, after a deal that we had struck with Jeremy Johnson and his attorney Ron Yangich, in my view, was blatantly violated by the United States Attorney's Office and by an agent that was working with the FBI, a cross-designated agent. I got so frustrated. That's why the article that you're talking about, where I told the feds, okay, if you want to make all the decisions on this case, if you're telling me, hey, I'm assigned to this case, I'm the prosecutor, but then on the other hand, you're telling me, but you don't get to make the decisions on evidence, on agreements, confidential communications with Mr. Yangich and Mr. Johnson. They so wanted the information that Jeremy Johnson had given to us, to the Davis County Attorney's Office, for the purposes of this state case, because they were prosecuting Johnson themselves. That an agreement that we had with Jeremy Johnson's attorneys about confidential proffers was just blatantly violated, and everything Jeremy Johnson told us that could be helpful was turned over to them, even though it wasn't germane to the 86 counts they were prosecuting him on. They just did it because they wanted it. And then it was a one-way street. They take what they want, they do what they want, but then they don't give back to me as a state prosecutor what Mark Shurtleff as a defendant is entitled to. So not only did I tell them, take the case back then if you're going to drive all the decisions and you're going to try to take away my prosecutorial discretion to do justice, to be fair, to provide due process, to keep confidential agreements as we should. But then you're not going to turn over evidence that the defendant is constitutionally entitled to as well. So not only did I tell them at one point, take the case back, and they didn't, but it got to the point where I filed a motion to compel against the United States government. I'm not sure if any state prosecutor's done that anywhere in the country before.
Sounds kind of unique. It'd be like making a motion to compel against a police agency.
Yeah, fair enough. If there has been a state prosecutor in a criminal case that's filed a motion to compel against the United States government before, maybe, but I couldn't find it in the research I had our folks do. But it got to the point where I was so frustrated with the control of the federal government, and particularly in my motion to dismiss, I articulate a few reasons why it was dismissed: violation of Mark Shurtleff's right to speedy trial, and also primarily then violation of Mark Shurtleff's ability to get and obtain the evidence that he's entitled to constitutionally to prepare his defense. It was so frustrating, the things that the federal government would give us and would not give us, that I filed a motion before Judge Mills to compel the United States government to turn over evidence that they had in their possession that they wouldn't provide.
They opposed that motion?
Oh, they did. Absolutely. The United States government opposed that motion. So kind of an interesting twist. So we had that motion to compel pending around the same time then that we ended up having to file the motion to dismiss because of issues that were creeping up with the speedy trial violation.
Never got decided?
Yeah, it never got decided because I got to the point where every day that this prosecution was pending and hanging over Mark Shurtleff's head, with the United States government not providing evidence he's constitutionally entitled to, it got to the point I couldn't wait any longer. We had a trial date pending in October. It had been continued before already because of the motion to compel and the litigation we were having with the United States government. Specific categories of evidence that Shurtleff was entitled to that absolutely exist. I wish we had the ability to articulate what all those things are here today, but for prudence, it's probably better I not talk about some of those things anyway. But I have email exchanges to back up and prove this. So there's no question that there was evidence that existed that Mark Shurtleff was entitled to in the possession of the federal government, and they were so intent that I not get it, that at one point in time there was a protective order that was obtained behind our back in United States District Court not allowing evidence, and the FBI relied on that. And I have emails to document and back that up. Mr. Rawlings, we can't give you the evidence because the U.S. Attorney's Office went and got a protective order, and so we have to abide by that protective order, and we can't give evidence that your defendant is constitutionally entitled to. This became...
And Mark Shurtleff in the middle of all of this.
Yeah, absolutely. A defendant and his attorney saying, we want this, 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 and this, and I'm agreeing with them. You're entitled to every one of those things. And we can't get them.
Troy, would you agree with me? Now, Mark was the Attorney General for 12 years.
Correct.
And there were, I think, 8 counts of bribery or accepting gifts or improper campaign donations that he was charged with. And from my reading of it, you know, some of the people that were making these complaints, or nearly all of them, were had some legal issues themselves, maybe defendants themselves. Would you agree with that?
I would agree with that. There were, just like with a lot of people, there was what would have been termed legally as impeachment evidence that was available, that should have and could have been available. One of the things we knew absolutely existed from the Southern District of New York related to a key witness. There were 52 FBI 302s or reports related to one of the most significant witnesses of all in the Mark Shurtleff case. I had to. It's one of the things when I filed the motion to compel to try to get. No. The particular witness I'm talking about is not Jensen. There were an interesting scenario with Jensen.
We're coming out. We're on a commercial.
All right.
So that's a rough break there, but fascinating show. I got Troy Rawlings, the prosecutor that dismissed the case against former Attorney General Mark Shurtleff, and we'll be right back after the break. Welcome back to Talk with Ted, number 21. Davis District Attorney Troy Rawlings is with me, and just by way of a little recap, Troy is the prosecutor up in Davis County, has been for 15 years now, former defense lawyer. Spoke earlier in the hour, if you're just joining us, that Troy went to law school to be a defense lawyer, to protect some rights and to protect people against government abuse. And after being a defense lawyer where he felt he had the power of persuasion, he thought his talents would be better served and that people would be better protected if he switched over and became a prosecutor. And we here in Utah are fortunate to have a prosecutor like Troy Rawlings, and he's been awarded, you've got a string of awards, Troy. We could get into that, but we're talking about Mark Shurtleff's case, and as you know, I represent Mark in his civil rights case, and it's a little hard to really get into the details of the case in this short radio program, but for those that are interested in more of those details, they're laid out in a 73-page complaint that we filed in the federal district court that's ongoing right now, and we address each of those charges head on and explain the circumstances which led to those charges and why we believe Mark never should have been charged in the first place. But Troy is sharing with us some challenges that he had in dealing with the FBI and trying to get information to Mark's lawyers. Mark was represented by Rick Van Wagner at the law firm of Snow Christensen and Martineau, a great law firm in downtown Salt Lake City. And I know that you and Rick have actually gone, I think, to BYU and to the University of Utah Law School and shared some details about this Shurtleff case and your experience. Is that right?
It is. I've particularly focused on why it was dismissed. You're right.
And then ultimately, the case went to trial against, well, it was dismissed against Mark Shurtleff, but then it went to trial against John Swallow. Correct.
And Swallow was acquitted on every count, as I was telling everybody he would be. I think a lot of people didn't believe me. If I would have been the prosecutor assigned to the John Swallow case, it would have been dismissed too, and that would have been spared because it's a case that shouldn't have gone to trial. I think that the jury got it right, and you can test me on this. A lot of local members of the media were asking for my off-record opinion as to what was going to happen before the trial. I told every one of them he's going to be acquitted. When you know what I know about this case, the more you learn about the case and the more as time went on through the Shurtleff case, I was able to get a handle independently on the evidence, independent of the FBI, independent of the Salt Lake County DA's office. It was clear. And so at least on the Shurtleff case, the public didn't have to see a very poorly put on dog and pony show that would have ended in an acquittal for Mark Shurtleff too. I take my responsibilities too seriously. I wasn't going to do that Mark or to the citizens of Utah.
You weren't in control of the Swallow, the
I was
John
not
Swallow
in control
case.
of the Swallow case, no.
Okay. And there were issues in that case where he was granted, or Jeremy Johnson, one of the key witnesses, was granted some immunity by the state, but not by the federal government?
That's correct. That gets into a very interesting issue, Ted, that I was discussing earlier about the dismissal on the Shurtleff case. The inordinate control of the United States government, the Department of Justice, over what we as state prosecutors could and couldn't do, what evidence we could and couldn't have. If we get time, I'll tell you.
Even though the defense was entitled to it.
Correct. If we have time, I'll tell you about a 3-terabyte hard drive story that in large part led to the dismissal on Shurtleff as well. But your question is spot on. The feds exercise so much control on the Swallow case, and I'll answer your question directly on Jeremy Johnson, but to give you one other example to set kind of the stage for that, so much so that one of the most incredible letters I've ever seen in my career was sent to Scott Williams, John Swallow's attorney, from the Department of Justice, from a DOJ attorney out of Colorado who had stepped into the shoes of the Utah office because of the conflicts of the Utah office, literally telling Scott Williams prior to John Swallow's trial what questions he could and couldn't ask. Incredible. You have an attorney that's representing a non-party. Yes, the FBI was the lead investigative agency, but the Department of Justice is not the prosecutorial entity in this case. But this is another one of the myriad of examples I have, example after example after example, of the federal government, the Department of Justice, flexing their muscles and saying what can and can't happen with this case, including what evidence we can and can't have. But Scott Williams got a letter before the trial from a DOJ attorney telling him, if you ask the agents about this, this, and this, they're going to refuse to answer. There was a telling moment in the trial.
Was that shared with the district attorney prosecuting the case?
Absolutely. And they knew it. The DOJ controlled the John Swallow case.
But did the Salt Lake district attorney have the authority to dismiss it if they chose to?
They could have done what I did. One of the differences is I did not allow the FBI and DOJ to control the Mark Shurtleff prosecution. I did. It was my job as a prosecutor to make those decisions, and I was not going to let them usurp that from me, even though they tried. And so the ultimate remedy for Mark Shurtleff, as his case drug on, as we couldn't get the evidence, as the month ticked by and his right to a speedy trial was being violated every day that went by because of the failure of the federal government to provide a plethora of evidence Mark Shurtleff was entitled to. And there are reasons why, and it's why I've been requesting funding for a grand jury, so I'll stay away from those things today. But those things continued to happen, and in the John Swallow case, similar things were happening. So it's so much so that an incredible event occurred in the John Swallow trial. FBI agent John Isaacson was being cross-examined by Scott Williams, John Swallow's attorney. Well, Scott Williams, of course, in his zealous representation of John Swallow, doing his job, not letting the FBI and DOJ tell him how he can and can't defend his client, which is what they're doing. They're telling us as prosecutors how we can and can't prosecute the case. So naturally, they think they can tell a defense attorney how he can and can't defend the case.
Sounds like something from the movies.
It's crazy. You couldn't make this stuff up. So they send this letter to Scott Williams. Well, in the trial, Scott starts to violate what he was told by the DOJ.
Not a court order.
Yeah, not a court order. One of the issues that Scott started to try to question John Isaacson about was the basis for the Department of Justice PIN, Public Integrity, back in Washington, D.C., who, by the way, they sent out one of their DOJ PIN prosecutors, a name that maybe nobody's heard of around here, but some of us, and that's Marquest Meeks, who was helping to control this case for the feds. But Scott Williams started to violate the directives that he was given as to what he could and couldn't ask John Swallow. So lo and behold, an attorney showed up for the FBI and made an objection during a break where the judge had to send the jury out of the courtroom. But you have an attorney that's not a party to the case. He's not a member of the Salt Lake County DA's office, not a member of the defense team, but an FBI attorney showing up objecting, saying that FBI agent Isaacson was not allowed by the Department of Justice. They wouldn't give him what's called a waiver or a two-way waiver. They wouldn't allow him to testify about the reasons why the Department of Justice, and John did give some answers. He started to go down that road, and it got shut down. And so the federal control over this case was so intense that even an attorney for the FBI shows up in court on the Swallow trial objecting and not wanting Scott Williams to be able to cross-examine a witness about something that would be clearly impeachment evidence that John Swallow would be entitled to. Why did the feds decline? What was their evidentiary basis? Why did they feel they didn't have the elements to prosecute John Swallow? Scott Williams was not allowed to go there. So we get back to your question about Jeremy Johnson. Jeremy Johnson would have testified in the case had the feds gave him immunity. So stop and think about this situation. You got, and I know I did it on behalf of the state.
And Jeremy Johnson was one of the main witnesses, correct?
Jeremy Johnson was a key witness. Jeremy Johnson was going to be an exculpating witness for Mark Shurtleff. There's no question in our interviews with Jeremy Johnson. As a matter of fact, and we may get back around to this later, but Mark Shurtleff actually is the very first person ever to go to the federal government about the possibility of Jeremy Johnson and Harry Reid, Jeremy Johnson, full tilt poker, bribing a United States senator. Shurtleff and Johnson knew each other well. They had a good relationship. But when Jeremy Johnson told Mark Shurtleff what was going on, what did Mark do? He didn't say, I want in on that. I want a piece of that action, Jeremy. Where are you getting this money from full tilt poker allegedly to bribe Harry Reid? Another story to get into. But Jeremy Johnson, what had happened, Mark Shurtleff went and basically ratted him out to the feds on November 2nd, and then an interview to the U.S. Attorney's Office, November 9th of 2012, to the FBI. Mark Shurtleff is the one who first blew the whistle and shined the light on the fact that there just might be a United States senator who might be taking bribes. And again, Harry Reid's presumed innocent. I've got to mention that. Nobody's been convicted of this, but it's incredulous that Jeremy Johnson was never charged with it either, if we can get to that point later. But on the immunity issue, so a large portion of the evidence that the United States government would not turn over to Mark Shurtleff was stuff related to Jeremy Johnson. There were other things too. There were other critical things too, but stuff related to Jeremy Johnson. So you get into the Swallow trial. Multiple days, day after day after day, the DA's office is trying to put Jeremy Johnson on the stand to testify because they thought he would help their case against John Swallow. Well, Johnson told them at least 6 weeks before the trial he was not going to testify unless he got immunity, not only from the state, which I gave him. I had deputization from Sean Reyes to grant immunity in that situation. And
Sean Reyes, our Attorney General?
Correct. Sim Gill also gave Jeremy Johnson immunity from state prosecution so he could testify. So we cleared the decks. So Jeremy Johnson, as far as the state of Utah was concerned, would have been able to testify in the John Swallow trial. He never got on the stand, though.
He spent time in jail instead.
He did. He was sitting in the jail waiting while his attorneys were trying to get the United States government to give Jeremy Johnson immunity to take the stand and testify in the John Swallow case. So guess what? Another stunning example of federal control over the Shurtleff and Swallow prosecutions. The United States Department of Justice back in Washington, D.C., that's where the level that this decision was made, they said no. They said, Mr. Salt Lake County DA Sim Gill and your prosecutors, we're not going to give Jeremy Johnson immunity for what he's going to say on the stand or what Scott Williams might ask him or where Scott Williams might go to try to impeach Jeremy Johnson's credibility. Specifically, Scott would have got into the Harry Reid bribe scenario and try to get Johnson's statements, his admissions, his emails, his documents, his meetings that were documented, all the things Johnson had laid out. So the Department of Justice is the ones who would not give Jeremy Johnson immunity to get on the stand and talk publicly in a very public forum and have to answer Scott Williams' cross-examination questions for impeachment purposes. So Jeremy Johnson never got on the stand in the John Swallow case because the United States government back in Washington, D.C., DOJ, PIN, Public Integrity, said no. Now, this is a guy they wanted badly. The feds went after Jeremy Johnson for 86
let's talk
counts.
Jeremy Johnson, a St. George businessman.
Yes.
I believe that he also may have had some interest in a bank, in a private bank down there.
He sure did. Sunfirst Bank.
Sunfirst Bank. And you had mentioned full tilt poker. Is
Correct.
This online gambling?
It is.
And if my memory serves me right, Harry Reid we know as the senator from Nevada.
Correct.
And a Democrat.
Correct.
And you would think that the senator from Nevada would be opposed to online poker to protect the brick and mortar industry of Nevada, the gambling industry.
He was until he wasn't.
So there came a point in time where Harry Reid supported online gambling?
In 2010. Not only supported, and we can go back with some details. And again, Harry Reid is presumed innocent. He hasn't been even charged with anything, although the Southern District of New York did charge 8 people in 2011 for money laundering through full tilt poker. It's called the Black Friday indictments. That'll be part of this story a little bit. I'll give you a little bit of an outline to answer your question. But again, everybody realize Harry Reid's, not only has he never been convicted, he's never been charged, and he is presumed innocent. But there are some questions of curiosity on a timeline that happen with respect to the issues that you're getting into.
And just tell me then, what did Jeremy Johnson have to do with Full Tilt Poker?
Okay, Jeremy Johnson was the primary owner of SunFirst Bank in St. George, Utah. Full Tilt Poker had persuaded Jeremy Johnson, so Jeremy Johnson got into a relationship. Full Tilt Poker was processing online poker proceeds through using Jeremy Johnson's SunFirst Bank in St. George to do it. So they had a bank in the United States processing poker. So oftentimes when I, kind of tell this story, I always start out Jeremy Johnson had a bank.
Jeremy Johnson had a bank, and when we come back after the commercial break, that's where we're going to pick up. Welcome back to Talk with Ted. My name is Ted McBride, a lawyer here in Salt Lake City. I'm a little tired, Troy. Maybe we'll just call it an interview. End it right there.
All right.
Fascinating stuff. You're a great guest. You're making my job really easy today, and I'm going to change the name of this show to Jeremy Johnson Had a Bank. You were explaining.
Yes. That's a significant component to issues surrounding Johnson and why he did not testify in the John Swallow case, and also why, in my view, based on the evidence that I can't fully articulate here today, the federal government wanted to control these cases and wanted to turn over certain evidence and not turn over certain evidence. And I can illustrate some of those things to what happened with the House investigation too. But Johnson had a bank, and we're talking a significant amount of money. On average, every day, Jeremy Johnson's SunFirst Bank was holding about $30 to $40 million of Full Tilt Poker's money that they were processing, with online poker.
Was this worldwide?
Yes. Full Tilt's headquarters was actually Dublin, Ireland at the time. And Jeremy Johnson, as the president, he was the majority owner of SunFirst Bank. The president was a guy named John Campos, who, interestingly enough, did get indicted for processing online poker money, and Jeremy Johnson never did. Go figure. Johnson, who owned the bank and was the one who was the point of contact with Full Tilt Poker, the point of contact with Harry Reid, and Jeremy started squawking about things that were going on. So John Campos, the president of SunFirst, got indicted for processing that poker money in 2011 by the DOJ, and there was a civil money laundering complaint filed too, but Jeremy Johnson didn't.
Where's Jeremy Johnson today?
Jeremy Johnson's in prison today for getting convicted of about a half a dozen or a couple, maybe 7 or 8 counts on 86 that was filed against him for totally unrelated issues.
Nothing with respect to the poker.
Nothing with respect to the poker. So the United States government went after Johnson for a whole bunch of other things. They lost on they lost about 90% of the counts and got a conviction on 10% of the counts against him, but not one of those things that they prosecuted him for had anything to do with the processing of online poker, even though he was the bank owner. Instead, the feds chose to go after a guy named John Campos, who had nothing to do ever really with the arrangements with Full Tilt Poker or with the communications with Harry Reid. So
it seems like you were a little skeptical of that.
More than skeptical of it, based upon what I know. And things that it's not appropriate to go into in this forum today because of what I'm still trying to accomplish, hopefully, with this at the end of the day. But Johnson has this bank. They're processing this Full Tilt Poker money. And you asked another related question earlier. Up and through about 2009, United States Senator Harry Reid had always been opposed to the processing to legalizing the processing of online poker. He had the brick and mortar constituents in Las Vegas who were opposed to it. Something happened quietly in 2009, and that is that the brick and mortar casinos started buying interests in the poker processing in online poker. Starting with Harrah's, I believe it was September of 2009. They started purchasing up, and some of the other casinos joined. And so now the interests switch going into 2010, a re-election year, for favoring legalizing online poker, because the brick and mortar casinos are now going to cash in on it too, and they're going to start making money off of it. And so we have an interesting scenario then in 2010 where Jeremy Johnson is owning the bank that the money is flowing through. And Harry Reid flips his position and begins to support the processing of online, legalizing it, so much so that in December of 2010, shortly after he was reelected on November 2nd, he introduced legislation. He tried to. He started circulating a draft of a bill, went to other senators, including Orrin Hatch, John Kyle, and others, to try to get support for a bill that would have legalized the processing of online poker in the United States. There's a lot of things that happened in 2010 that get up to that point in the story that I'm going to be really careful about. But in fact, shortly after being reelected, Senator Reid did make that proposal. It got shot down, and it was a flip of position for him. There had been other members of the United States, particularly Congress. Barney Frank from Massachusetts had tried, to get online poker legalized, and Harry Reid had been one of the main oppositions in the Senate to it until in 2010 he no longer opposed it. And not only did he not oppose it, but he had a 157-page draft bill that he circulated, and he tried to attach it to a Bush-era extension of Bush-era tax cuts. Is the way he tried to get it into the system. It failed. He didn't get enough support for it. But the relationship between Jeremy Johnson and Harry Reid became central to our case. It became central because Mark Shurtleff was, again, a witness against what they had done. Mark Shurtleff was the initial whistleblower to the United States government about what he knew about those transactions and those situations. And so shortly after Mark Shurtleff meets in Washington, D.C. in March of 2013, he first reports it in November 2012.
While he's still Attorney General.
While he's still Attorney no, by this time, I think Swallow had been elected. So Mark was now out, and Swallow was in 2013.
Okay, you said that.
But in 2012, you're right. In 2012, when Mark reported, he was still the Attorney General.
He was just finishing up, not running for re-election.
You're correct. That is the timeline. Yeah. And then in 2013, when he's no longer the Attorney General, Mark actually reported what he knew about Johnson and the allegations related to full tilt poker, the processing of money in the bank, to some key individuals close to Eric Holder directly. I won't name those individuals here today, but after Mark made that report...
Eric Holder was the United States Attorney General at that time?
That's correct. After Mark made that report, it appears at some point right around that time, Mark became a more significant, serious target of a federal investigation.
Mark did.
For
reporting this.
I'm not going to tell you that here today.
After reporting this, that happened.
After reporting it, the federal interest in Mark Shurtleff increased significantly in taking a look at what activities he may or may not have engaged in. The feds didn't decline on Mark until September of 2013. They ultimately declined. They ultimately said no as far as prosecuting him at the DOJ PIN level. But Mark was under the microscope then for most of 2013, and significant things and events in that investigation of Mark transpired after he reported what he had been told and what he'd learned about Jeremy Johnson's relationship with, or alleged relationship with United States Senate Majority Leader Harry Reid. So that whole relationship posed a conundrum for the United States government in certain ways, and so one of the main things that the United States government wouldn't turn over to us was information related to Jeremy Johnson, his allegations, his interviews with the Southern District of New York in the 2010, and then culminating in the 2011 indictments.
And perhaps some of those were inquiries on the subject matter that Mark Shurtleff had raised?
Absolutely. Yeah, some of those touched on exactly some of the issues that Mark Shurtleff had raised. But all of those things also would go toward there were allegations being made by Jeremy Johnson in the John Swallow case as well. So both Mark Shurtleff and John Swallow were entitled to what information was in the possession of the United States government that could have impeached Jeremy Johnson's statements against either one of them. Again, Johnson was going to be more exculpating than inculpating. In other words, tend to give evidence that more exonerates than.
But he was still a prosecutor's witness.
Yes. Well, he was going to be particularly in the Swallow case. In the Shurtleff case, interestingly enough, Johnson was primarily maybe going to be a defense witness, but the defense is still entitled to that information material to vet Jeremy Johnson as their witness. I'm entitled to it as a prosecutor as well, if I'm going to cross-examine Johnson, or if we call Johnson as a witness ourselves. Either way, we're both entitled to the evidence and material. And it was the United States government and the FBI that made Jeremy Johnson a central figure in the Shurtleff-Swallow investigation. And then to turn around and tell us that we can't have. There was material in the possession of the United States receiver that was seized when his iWorks company was seized.
Jeremy Johnson?
Jeremy Johnson's material that we weren't even told about. Another kind of stunning example, I get a phone call from a defense attorney one day in Salt Lake that I know and respect a lot. This defense attorney tells me, and then sends me the document. Defense attorney calls and says, "Are you aware?" And we knew that it had to exist because information that we had. "Are you aware that in the possession of the FBI there are multiple files that Jeremy Johnson made, recordings, those sort of things that Johnson made that include John Swallow and Mark Shurtleff?" I said, well, we know that those items should exist. They were supposed to have existed, and I won't get into today how and why. And so she indicated, this defense attorney, well, guess what? I've got a report from the FBI crime lab, the RCFL, Regional Forensics Computer Lab, that verifies that those things you've been asking for indeed do exist. There are multiple files with Shurtleff and Swallow by name that were never even disclosed to us by the United States government. I find out about some significant evidence that we knew from other sources would exist. FBI and DOJ are saying, no, we don't have it. We knew it was down at the receiver's location in Nevada. Then we get independent confirmation through an RCFL report given to me by a defense attorney in another case that was related to Jeremy Johnson, that verifies everything we had been asking for and seeking. It actually did exist, these materials, and it simply wasn't turned over to us. And one of the reasons is because there was a federal order that was obtained saying that we couldn't have these materials, and we didn't know about that order until I start squawking about, hey, I now know this exists. Here's the RCFL report, folks, FBI, DOJ, this material, why don't we have it? Why haven't you disclosed it? Why haven't you given it to us? Why haven't you provided it to us? And it ultimately came out that a DOJ prosecutor had sought a protective order in the United States District Court, and they were relying on that protective order to not provide information to us related to one of the, if not the most key witness on multiple of the counts related to the Shurtleff Swallow case. This is a crazy scenario, Ted. Thing after thing after thing happened that just it became insane, culminating in an issue. If you don't mind, I want to mention about
keep going. 3
terabytes.
I was just going to bring you there.
Yeah,
we're on the same page.
This is so crazy what happened with this situation that as we're moving in then to 2016 with the Mark Shurtleff case, the motion to compel is pending. We're asking for a plethora of information and material that we know exists. The DOJ is saying no. And
you say you're asking for it because Mark's lawyers were asking of it from you.
And they joined my motion to compel. So
that's unprecedented.
Yeah, yeah, probably. Interesting scenario. So you have both the defense attorneys for Mark Shurtleff and the prosecutor for the state of Utah seeking to compel material evidence information from the United States government, and them taking the position through a DOJ attorney in Colorado, no, you can't have it because we say it's not material to your case. So that was their position.
Did they allow the Judge Ruby Mills to do an in-camera review of it?
No.
Wouldn't that be the proper procedure?
It could have been had we got to that point. Had I allowed the case to labor on longer and linger, it might have eventually got to that point on the motion to compel, but in good conscience, to keep my constitutional oath to try to do justice, equal protection, due process, I had to dismiss before we got to that point because the feds had drugged this out long enough. We already had to continue the trial date one time, and then what happened in the middle of 2016, significant event that was the last straw. We had a couple of things. The McDonald decision came out. Former Virginia Governor Bob McDonald, that decision came out. That had a significant impact on 2 of the counts called the gift counts in the Shurtleff case. Basically, that decision pretty much all but gutted the potential prosecution of a couple of the counts. So the McDonald decision, I dismissed on Mark Shurtleff shortly after that decision came out. That was one of the factors. The other factor, though, that would have led to the dismissal of those counts anyway, and that led to everything else, Mark Shurtleff's right to a speedy trial, again, to summarize, is being violated because of, in our view, the failure of the United States government to cooperate and provide evidence, information, and material that he is constitutionally entitled to and that the state is. So as we're doing the motion to compel litigation, lo and behold, some of the things I was asking for, they said, okay, we'll give you. Let's try to work out a negotiation. Maybe some of these things that we've said before didn't exist. Okay, maybe they do, and we'll give them to you. So they started to do a rolling production and produced a few of the items. So we continued the hearing on the motion to compel at one point, the oral arguments on it, because the feds started to give a little here and a little there. For example, all the 52 FBI 302s related to Jeremy Johnson, they gave all completely black.
And black. For our callers, what's the 302?
An FBI report.
Okay.
Yep. Totally redacted, pretty much total sea of black with nothing in it of relevant value. Okay, so we'll give you something, yet we're going to give you nothing at the same time. So as this is pending, and they're starting to slowly, like a tire with a small hole in it, leak little things to us, and the case is dragging on. We're getting closer to trial. Again, we had to continue a trial once. We continued the motion to compel hearing while we're trying to work with them and get evidence and information. Another incredible thing happens. There is 3 terabytes. So they say, okay, we're going to put everything together for you. We're going to give you a complete production to the degree that we can, except certain things. There were things that they absolutely were never going to agree to give us. For the same reason they didn't give Jeremy Johnson immunity. A lot of those things related to those issues and what Jeremy Johnson was saying and claiming. It's presented to my office 3 1-gigabyte drives of material, and then there's an extra hard drive as well. So just over 3 terabytes. So it's 3 big hard drives that are 1 terabyte apiece, and then a 1 gigabyte, basically disk. I also get then, along with that material, a letter from the Salt Lake County DA's office, and then a subsequent order from Judge Ruby Mills saying, hey, by the way, you got these 3 terabytes now. A lot of the stuff you've been squawking about, may be on there. We're kind of throwing the kitchen sink at you. It was in an unsearchable format to begin with. We've got a trial coming up on Mark Shurtleff in just a couple months, and they deliver this. But here's the kicker. But you can't look at it, state prosecutor. You got these 3 terabytes.
Who says this?
The judge. The DA's office gave me the initial letter first. Got a letter from the DA's office saying that because there is tainted material. In other words, what had happened, Ted, with these 3 terabytes of maybe the final production that's hopefully going to have some of the things that we're asking for on it, we couldn't look at it, review it, because shortly after it's produced, Scott Williams, John Swallow's attorney, rightfully calls the attention that there's a whole bunch of material. Scott Williams got it first, looked through it, raised a red flag immediately with the court. There was a plethora of material on those hard drives that should not have been there, that shouldn't have been able to be in the possession of the investigators, in the possession of the prosecutors involved in this case. So Scott Williams properly goes and gets an order from the judge, Judge Mills, and I don't falter, Judge Mills properly entered an order saying, okay, nobody can look at this stuff. So I got a letter and an accompanying court order saying, I'm not to review this material because I might come across the tainted items that are in there that I shouldn't have and see, and I can't give it to Mark Shurtleff. Are you kidding me? How do I go forward with the case anymore at this point? I now have 3 terabytes hard drives that purportedly comes from the federal government that is evidence in this case, may have some things on it we've been seeking, maybe not, we don't know. And I'm told I can't even look at it myself, let alone give it to the defendant in the case I'm prosecuting. We've got a trial again in a few months. So we say, okay, when can...
If I know Troy Rawlings, he's going to dismiss that case.
And to this point, to this day, that order is still in place, and that has arisen in a couple of other contexts. How does that happen, though? That's the key. It shouldn't. The scenario...
We're into another commercial.
Okay.
And when we come back, we're going to follow up with that question. How could that happen? And it shouldn't.
Okay.
Be right back with Troy Rawlings. Welcome back to Talk with Ted, a show about nothing. Number 21, Troy Rawlings and Jeremy Johnson has a bank, I think we're going to call it. When we were going off, the question was, how could this happen?
Related to the 3 terabyte hard drives with tainted material. So they're delivered. We're told you can't look at them, can't disseminate them, even though you got a trial coming up right away. And what happened, the reason that those hard drives were tainted, again, it's inexplicable. The brief process, so people can understand it, like when a search warrant is done and you seize somebody's evidence, like you seize books, papers, computers in this case, there is a process in place where there is supposed to be a taint team. It's a separate team of agents. The FBI, the DOJ, they do it all the time. State prosecutors do it all the time. You go through what's seized to make sure that there's nothing in the material that the prosecutors involved and the investigators involved in the case could have that they shouldn't. For example, attorney-client privilege material was a big one in this one. Communications between defendants and their attorneys, that's a huge no-no. I, as a prosecutor, shouldn't have those. The investigators shouldn't have those. They should never even be in our possession. They should be excised out of the material that goes into the case file that is accessed and used by the investigators and prosecutors.
But the 3 terabytes couldn't have been all that type of information.
No.
But that type of information was mixed in with other stuff?
Apparently so, because I can't even look. I'm under a court order. I can't even. I haven't popped those hard drives in to look at them because I'm under a court order not to.
Why bother giving them to you in the first place?
Well, it's a question I want to explore. And it's one of the reasons that why I have been beating the drum for a few years that it would be nice if we could have a grand jury here in the state of Utah look into a lot of these issues.
And is it the issues between Jeremy Johnson and Harry Reid?
That's one of the issues that would be nice to inquire about. There's a lot of curiosities there that I can't get into or lay out for you today above and beyond what I have. But this 3 terabyte scenario it's incredible. So here's how what happened that shouldn't have happened. The material that should have never been in possession, that caused the judge to enter an appropriate order saying you guys can't have it, was material that somehow ended up in the possession of the Salt Lake County District Attorney's Office through a cross-designated FBI agent. So what you had happening is I'm pushing hard. We're trying to get this material.
You say cross-designated, that's a state agent who was also then authorized by the feds.
Correct. So apparently this state agent, for whatever reason, who was part of one of the keys, helped write a lot of the search warrants, one of the main investigators into.
And he's a defendant in our case.
Yes. Okay. One of the defendants in your case, who's involved in this situation somehow, for whatever reason, has the tainted material in his possession. We're talking about material that never should have been in his possession.
Where did they get that?
That's one of the things I want to know. The taint team should have had it. Again, the separate taint team that the FBI did have and set up that should have excised out all that material, but that material should have been completely separated, segregated. It never, ever should have been in the possession of the investigators into Shirtliff and Swallow, but it was.
And had it was in the possession of the defense lawyer, Scott Williams,
yes,
who identified it as, I shouldn't be seeing this material.
Yeah, and Scott Williams was like incredulous that this material was in there because a lot of it related to his client and communications with his client and the attorneys.
Gotcha.
So what happens is, so the FBI, the cross-designated agent, they package all this material, they take it to the Salt Lake County DA, they take it to an entity called Salt Lake Legal for processing to put everything on PDFs and produce these 3 terabyte hard drives, and then lo and behold, there's all this tainted material that's on these hard drives that never should have been on the hard drives to begin with, ever, because it shouldn't have been in the possession of Salt Lake Legal. They got it from the Salt Lake County DA. It never should have been in the possession of the Salt Lake County DA. Salt Lake County DA got it from the FBI and the cross-designated agent who were leading the case against Shirtliff and Swallow that never should have had it to begin with. Oh, my goodness. You're talking about a massive problem here. So, of course, the judge is going to enter an order saying, oh, boy, until this taint stuff can be cleaned up and removed and excised and a clean production of documents can be given.
Sure, what could she do at that point but issue just a broad order?
Yeah, that's what she did. She didn't have any choice. But then the problem that I have as a prosecutor is, again, a trial that had been continued. We've been trying to do a motion to compel. There's a whole list of other evidence that we're seeking anyway, and now this on top of it. So the 3 terabytes that were finally given that may have some of the things we've been questing for, it was represented that certain of those things would be on there and certain of those things wouldn't. Can't even look at it.
You can't look at it.
To this day, I can't look at it, and I can't give it to Mark Shirtliff, and we were supposed to have gone to trial in 2016. It's crazy. As a prosecutor, to carry on that case, and that all happened around the same time the McDonald decision came out, it was done. So if folks are interested in reading, my motion to dismiss is based upon constitutional violations and also in factual innocent explanations that Mark had to the various counts too. It's a totality of the package. Mark had interesting exculpating evidence and information that was presented to me by his attorneys that kind of went to the heart of each count and the problems with each count from an evidence standpoint anyway. And those are significant if we had time to address those. I know you will, through your case. But also as a matter of constitutional principles and law, a defendant has a right to a speedy trial. Mark Shirtliff hadn't waived that right to a speedy trial. We've been fighting the feds for evidence he's entitled to. They're not giving it to us. And now, lo and behold, when we finally get a production of 3 terabytes, we're told you can't even look at it. So what does that mean? The defendant can't access it. I can't either. We can't prepare with it. We can't see what witnesses, what documents might be there. Is there exculpating information on there? It's an unfathomable scenario that I never in my wildest dreams could have imagined could possibly happen, particularly on any case.
And such an important high-profile case. And Mark Shirtliff was a distinguished public servant.
Yes, and we're talking the involvement of significant, reputable, professional agencies involved here, where this material ends up on hard drives that should have never ever been there. And to this day, I don't know if they've cleaned it up or not, because I had to end up dismissing on Shurtleff, and there's been a couple of attempts to try to get access to the material on, like for Shurtleff, for expungement, things like that. But that order is still in place. So I've had to tell Shurtleff and his attorneys, I still to this day, I can't give it to them for any I probably...
Well, there's still some litigation alive on our end, so maybe we'll address that issue.
Yeah, fair enough. So I guess to your public, the question is this. How would you feel? You're a defendant. You're in the crosshairs of the government. There's a trial coming up. The government is in possession of a whole quantity of evidence that you want to know, that some of which may be able to help you, and that doesn't help you. You want to know how to prepare for it, to deal with it, to defend it. And you're being told, nah, you can't have it, Mr. Defendant. You can't look at it, Mr. Prosecutor. You can't either, yet we're still supposed to go to trial when we can't even look at, review, prepare, use the evidence in any way.
And yet they still went to trial against John Swallow.
They did. Swallow's issues on that terabyte hard drive were a little bit different because the tainted material went to Swallow himself, so Scott Williams was able to access it because the attorney-client privilege material, so Scott was able to access it. It's in the Shurtleff case we were ordered no, that you can't.
You had mentioned a name during the break, Stephen Reich.
Yeah, interesting.
Did I pronounce that correctly?
Yeah, you did. Stephen Reich, a guy that actually developed a personal relationship with, like him a lot, but it's an interesting, I think, another one of these curiosities that I think would be fun for people to know about. When the Utah House of Representatives, the investigative committee, was being established because the allegations that were coming forth against John Swallow, and they decided we need to look into this. We want to do this in a nonpartisan way, unbiased way, so we put together a committee, and then we're going to go out and we're going to contract with somebody to do the investigation for us, make recommendations, make findings.
You see that sometimes they'll hire an outside law firm to
Yeah.
do an investigation with the NCAA or something.
Right, exactly. So that's what they did. Don't fault them for that at all. I think the House of Representatives, in good faith, making a good effort to do that. What's interesting about that is they end up contracting with a law firm called Aiken Gump and an attorney named Stephen Reich. A brilliant guy. Met him personally multiple times while he was out here dealing with these cases.
Not a Utah firm.
No, well, Aiken Gump is an international firm. They have offices all over the world, a big firm. So what is a curiosity to me that we learned as this case progressed on Mark Shurtleff. Stephen Reich, the individual who was hired to come out here by the state of Utah, was an individual that had just left the Department of Justice to go with Aiken Gump right before the bid was submitted. So to give you, and then I want to tell you a little bit about Stephen Reich. Again, a very capable, talented, brilliant man. I have a press release that's interesting. Senior DOJ official Stephen Reich joins Aiken Gump, dated Wednesday, July 24, 2013. Stephen Reich left the United States Department of Justice to go to Aiken Gump. Aiken Gump was trying to get this contract out here in Utah. You have then just a few weeks later, August 9th, the State House Investigative Committee announces that they're going with Aiken Gump. Aiken Gump's going to do this. Stephen Reich is going to be the great dragon slayer. He's going to lead this investigation into John Swallow. Interesting thing about Stephen Reich, who was he and what was his background? I'll read to you really quickly just one very short paragraph that kind of helps summarize it about his prominence in the legal world. At the Department of Justice, so remind you, this is right before he leaves to go to Aiken Gump to come out here to Utah. He leaves weeks before. Aiken Gump submits bids, and then they come out here to Utah to do this. At the Department of Justice, Mr. Reich was a senior advisor to Attorney General Eric Holder and Deputy Attorney General James Cole, and supervised the staff of nearly 24 lawyers responsible for defending the department and its leaders in investigations conducted by Congress and watchdog agencies. Earlier in his career, Mr. Reich was a senior associate counsel to President Clinton, at which time he led a team responsible for defending the president and other White House senior officials in independent counsel congressional investigations. Reich had helped defend, he was one of the lead attorneys defending Bill Clinton in impeachment. Reich was one of the lead attorneys that helped Eric Holder in the Department of Justice during the Fast and Furious hearings. Reich was on Eric Holder's senior executive committee. In 2011, when Full Tilt Poker was indicted in April, and a whole bunch of defendants and all this massive amounts of money, the feds were going after $786 million. That happened April 2011. Stephen Reich had been in private practice for a while. He'd been in the DOJ before, left, came back. Eric Holder brought him back in June of 2011. While this Full Tilt Poker case is pending, And then Reich becomes a member of Eric Holder's executive level. He becomes an associate attorney general. So basically, in terms that people can understand it today, one step below Rod Rosenstein. So in today's, everybody probably knows who Rod is. You've got the Attorney General, then Rod Rosenstein, the Deputy Attorney General. Stephen Reich was one level below that, a guy named James Cole. That's the level that Stephen Reich was at in the United States Department of Justice, and he was dealing with congressional affairs issues. He was there in 2011 when the Full Tilt Poker cases were pending. And he leaves the Department of Justice in 2013 when the House investigation is starting to investigate John Swallow. He leaves that job and that position to go join Aiken Gump, comes out here and does this. He didn't stay with Aiken Gump. He's now with Deutsche Bank. He leaves to go with Deutsche Bank. One more item of curiosity about that. If you look at the 214-page House investigation report, there's barely a mention.
From Utah.
From Utah, that was prepared by Stephen Reich, Aiken Gump, and those who were helping him. There is a footnote, there's a brief mention related to Harry Reid, but they stay primarily away from it. What you don't see in that report is a 33-page report that was prepared by two investigators looking into that whole angle and how Jeremy Johnson, the bank in St. George, Sunfirst Bank, the Full Tilt Poker processing, how that played in to the scenarios with John Swallow and Mark Shurtleff. You don't see that in that report. Casper and Lindquist did it. They're here in Salt Lake. They exist. They're real people. They did this investigation. When they submitted that report to the House Investigative Committee, they were fired. And their report... They were fired the same day. And their report that deals with the issues related to John Swallow's relationship with Jeremy Johnson and Jeremy Johnson's relationship with Harry Reid and whether or not John Swallow had given an opinion related to Full Tilt Poker processing, it's glossed over in the report, but it's pretty much excised. Their addendum to the report never makes it into that report. And so, again, you have a whole bunch of interesting, I call them items of curiosity.
Who's in control, Troy?
Well, so the argument that I make, and I know a lot more that I can articulate here today, obviously, is the Department of Justice was in control of this whole thing. The Department of Justice even controlled the House investigation, in my opinion. Stephen Reich was in Eric Holder's weekly executive committee meetings up until the day he left and came out here with Aiken Gump to Utah.
How much did Utah pay for that investigation, do you know?
I believe it was about $4.5 million.
And you know they won't pay Mark Shurtleff's legal bill.
I understand that.
State of Utah. But they pay $4.5 million for an independent investigation that you're saying was headed up by a higher up at the Department of Justice, or a former higher up at the Department of Justice.
Exactly. Until the day he left, and he had been involved in issues with Congress. He was brought back in right after the Full Tilt Poker indictments. Had been involved with Fast and Furious. Stephen Reich is a very talented attorney, a very brilliant man, very effective at what he does. They were effective in the report that they put together and getting the goal, that they want to accomplish. But again, what's interesting to me is, the point I'm making is, just like Jeremy Johnson wasn't given immunity to testify in the John Swallow trial at all, the Fed said, no, you can't talk publicly. The House investigative report is pretty much absent and silent in all of the things that Casper and Lindquist looked into that are similar to the things Jeremy Johnson would have testified had the feds given him immunity to do it in the Swallow case.
Crazy stuff. Stuff for a movie. I got to tell you, you're a brilliant lawyer. You're talking about other lawyers being brilliant. You're a brilliant guy, a highly respected guy. I appreciate your time today, and I look forward to working with you again. And I expect to call you as a witness in Mark's case. And I, on behalf of Mark Shurtleff, I want to thank you for your integrity, honesty, and being forthcoming with this stuff, because I know it's may not be easy for you. But Troy, I wish you well, and thank you so much for appearing. Folks, thanks for listening. It's Ted McBride, Talk with Ted. I'll be back on Thursday afternoon with Mark Shurtleff, and I'm sure we'll have a few comments on today's interview as well as the Mueller investigation. So tune in on Thursday. Thanks for listening.
Click on Health for more information or call